MARIAH. MARIAH. All right, let's begin our afternoon court calendar by calling the case of the state versus, is it MARIAH?
Yes, sir.
And is it WOELKE?
WOELKE.
WOELKE, thank you. It's case number 25 CM 2730. Appearances, please.
ADA Sam Smith for the state.
Ms. WOELKE appears in person and by Dorothea Watson. We have received a copy of the criminal complaint. We waive its reading, reserving all jurisdictional objections. We would enter not guilty pleas to the charges.
Okay, thank you. And I believe she does have an open misdemeanor case assigned to Judge McNamara, so we should get this case assigned to the same judge. Attorney Watson, you probably just said it and I spaced it. Does she qualify for a public defender?
She does, yes.
Okay, real good. And what's the state's position regarding?
No, just 1 second.
Sure. She does have attorney Sheehan in her pending case.
Yeah, it's unclear from the form whether or not she is eligible for a public defender. She was evaluated. She thinks she was found eligible. But the form does not so indicate one way or the other. So perhaps she should call them back when she can.
I think that's a great idea.
Yeah.
If you qualified for Mr. Sheehan before, you probably will qualify for this case too, but they do require that you make the application in each case. You're covered for today. You have an experienced lawyer that'll help you. What's the state's position regarding bail?
State's requesting a signature bond along with the condition that the defendant make no acts or threats of violence towards AEG and to not consume or possess alcohol.
No objection.
I'll order a signature bond with those conditions. We'll get a not guilty plea entered on the defendant's behalf, and then we'll send this case on to Judge McNamara. I'm just looking to see if there's a specific date we can give now.
January 14th.
Okay, and you'll get that in writing.
Date is other word.
That would have been the plan, yeah. I wasn't sure whether he could accommodate that, but I think that's exactly what we want to try to achieve.
Okay, that's perfect then.
Exactly, yeah. We'll see you later. Good luck.
Next up is Trent HAAK. Trent HAAK.
All right, we'll call the case of the state versus Trent HAAK. It's case 25 CF 2599. Appearances, please.
Okay.
ADA Sam Smith for the state.
We have received a copy of the complaint. We'd waive its reading, reserving all jurisdictional objections. We request a prelim. The address is correct on the criminal complaint. And Mr. HAAK, it's not been determined if he's eligible for a public defender.
I see. Well, Mr. HAAK is in custody on a hold. He also does have 3 open felony cases assigned to Judge Highland, so we need to get this case assigned to Judge Highland. It does appear that he's been in, I think, continuous custody since September 30th, when this is alleged to have occurred. What's the state's position regarding bail?
The state is requesting cash bail in the amount of $2,000 along with the conditions that the defendant not consume or possess alcohol and that he be banned from all pick and save locations. Reason for the cash, by my count, it looks like this defendant now has 5 open cases. I believe they're all retail thefts, and most, if not all, involve allegations of what I believe to be an alcohol problem or alcohol abuse. So I think that condition is appropriate. And for the reasons I already stated, I think cash is appropriate here. Thank you.
Didn't the state stipulate to amend his cash bails the signature bonds in his other cases like a week ago?
If his other case is what?
I said, the question was, didn't the state stipulate to amend his cash bonds, the signature bonds in the other cases like about a week ago?
Okay.
I was not aware of that. I can take a look.
Sure, and I just happened to pull up a couple of those cases. I guess I'd refer you to 25 CF 2320 and 2101.
It's consistent with what Mr. HAAK is saying. Apparently, he has an ATR that he's going to begin next week. And the hold, he explains to me, would be dropped at that time. This is theft of alcohol. If that's all accurate, I think we'd all like to see him get some kind of treatment. I'd ask that he get a signature bond here too.
And any response or additional information from the state?
No, what you were mentioning, now I'm seeing is correct, but nothing new to add.
Okay. Given the number of cases, this I think would ordinarily be a cash bail case. In fact, presumably in response to the state's requests in those earlier cases, other commissioners set cash bail in those cases. At the same time, I guess I can't reconcile a stipulation to set signature bonds in those cases a week ago with my now setting cash on a case that precedes the charging of even those other cases. It's just hard to reconcile those things, and I guess I won't. So I'll take my lead from that stipulation. I'll set a signature bond here. I will adopt the conditions about pick and save and alcohol. I think those were the requests.
Thank you so much.
Not a problem. We'll get a not guilty plea entered on Mr. Hack's behalf to the misdemeanor charges. Actually, there aren't any. They're both felonies. Did you want a prelim on within 20 days?
Yeah.
We'd waive time limits for the prelim and ask for a status.
You can. You may not want to talk about the case itself, though, because we do record the proceedings.
I understand. I'm not talking about this. I didn't even I wasn't even under the influence from my attorney about having another initial appearance.
Okay, that's cool.
So-
Okay. Yeah, and you'll have an opportunity to sort out what to do next with this case with your lawyer.
Yeah.
I understand that there was a decision made to now in mid-November
Yeah,
charge this event
thank-
from a month and a half ago. And
Yeah.
you may not have expected it here today. I get it.
Yeah, no, I didn't.
All right, but you're set for today. Take care now.
Thank you so much.
Next,
Sure, bye-bye.
Aaron Benavides.
Actually, before he goes, maybe I do want to look at one thing procedurally, because I'm a little confused. You're not like in any other trouble or anything, Mr. Heck, don't worry. I'm just trying to sort out,
Yeah, they just did a signature bond last week.
Yeah.
right?
that's it.
I was a little bit confused because the jail booking record had already a bond set and some other things in connection with this police department agency case number. And it appears as though case 2320, one of those that was already, it's already in the system, so to speak, arises from the same police department case number. But as I look at the allegations, they are different, involving different stores. So I don't think there's an issue here with it being doubled or
Okay.
anything, but it did cause me a little bit of confusion about whether that was a possibility.
So I still got the sick bond.
Oh yeah, that you're still all good with the stuff we did here this afternoon. In fact, there really is no problem at all with any of this. I just wanted to make sure that there wasn't a mistake made and that you weren't getting charged twice for the same thing. That
Thank you.
once in a while will happen, so we try to check that. Take care.
Aaron Benavides. Aaron.
All right, why don't we next call the case of the state versus Aaron Benavides, case 25 CM 2720. Appearances, please.
ADA Sam Smith for the state.
Mr. Benavides appears in person and by Dorothea Watson. We have received a copy of the criminal complaint. We waive its reading, reserving all jurisdictional objections. We would enter a plea of not guilty to the charge.
All right, thank you. Mr. Benavides is also in custody on a probation hold that stems from a conviction in branch 2. So we should get this case assigned to Judge Kondar pursuant to the local court rule. What's the state's position regarding bail in this case?
The state is recommending a signature bond, along with the condition that the defendant have no contact with Jeffrey M. Jeffrey is common spelling and last initial is M as in Mary, and a ban from the Capitol Square.
We have no objection to that request. We'd ask that his mail be sent via the Dane County Jail at this time.
All right, and I'm happy to have that be updated that way on the computer. Sometimes I get a little concerned about doing that because if a person gets released, then we don't really have a good mailing address for them. It's sort of unfortunately common for me to do a bench warrant return hearing where that has occurred.
The only other address I have to offer is care of the Beacon, 615 East Washington.
I guess I'd prefer to use that because if the agent lifts the hold and he's released, then if he's in the jail, we know where to find him. If
Okay.
he's not in the jail, then we need to be able to get him notices and all of that. So I think that's fine. If I didn't say it, I'll order a signature bond with the two requested conditions. We'll get a not guilty plea entered. Of course, now, Mr. Benavides, it's between you and your agent as far as getting out.
And I believe one of the conditions was banned from the Capitol Square area. I don't know if he was provided a map already.
Looks like, whoop, not that one. It would be the one in the middle there. There we go. Deputy Hawley's giving him a copy of the correct map at this point, and we'll have one in the court file or the virtual court file also.
I don't think I mentioned he is eligible for a public defender.
Okay, thank you for that. Sounds like you're in good hands that way. Good luck to you, Mr. Benavides.
Thank you.
Do we need a thread tonight? No.
You have the normal.
Just make sure. Thank you for transparency. This sort of change.
That's correct. You should talk to your lawyer about it.
Okay. Yes, I know.
You should know.
All right, next up is Isaiah Abernathy-DUEWEL for bail bond hearing. All right.
Is it a bail hearing or I have the
Yeah.
complaint? So.
It's a return on a warrant.
And your office just likes to provide complaints for all of the cases.
Okay, not my office, but yes.
Fair
The office your fault.
That's
point.
right.
Well, why don't we call the case of the state versus Isaiah Abernathy-DUEWEL? It is case number 25 CF 2069. Appearances, please.
ADA Sam Smith for the state.
Mr. Abernathy-DUEWEL appears in person and by Dorothea Watson.
All right, well, we're here in return of a warrant issued in this felony case. The warrant was for a missed preliminary hearing related status conference on November 10th. At that time, a $300 cash bail was also forfeited. Lurking behind the scenes is a bench warrant issued by Judge Burrs in a separate misdemeanor case. That was for a missed appearance back in early October. Because that's a branch 11 case, that warrant is returnable to Judge Burrs. So the irony here is I'll be able to address bail on the felony case. The misdemeanor case will have to be separately addressed by the judge. There is a hearing in front of her scheduled next week, so that is on the books at least. Let's make sure we have the best address for Mr. Abernathy, I guess, to start with.
The address for him at this time is. He has not been interviewed by the public defender's office. Is 208 East Dolan, Madison, 53713,
Is that apartment 205?
number 205.
Suite 205.
Okay, great. Well, that is what we have, so all's well there. He does have an attorney through the public defender's office appointed, so he's covered that way. Do we have any information about what happened with the court appearance?
In looking at CCAP, it appeared to me that although he missed maybe I'm mistaking him for someone else, but I thought that the notice came back as undeliverable. Maybe that must have been in his misdemeanor case that I was looking at. If I could have just one.
Absolutely.
Apparently, he informs me that his case manager, he has case due to mental illness, and that his case manager typically helps him with those court dates, and apparently did not in this instance. He was arrested, he informs me, at the shelter. So I don't think he had left town or anything along those lines.
Well, then that's consistent with the address on the booking. State have a position on bail.
Yeah, I'm not unsympathetic to the defendant's situation. However, I think it's ultimately up to him to know when his court dates are. The state's requesting $750 cash with the reinstatement of the same conditions. I'm happy to provide those if the court needs them.
Well, I have them, but let me just say them out loud so everybody hears it. They're not to have contact with John Lee W. and not to be at the Beacon.
Okay, well, that's problematic, of course.
Well,
I
and
don't think he
if
had.
I'm not mistaken, I think the Beacon is a different location.
Oh, the different shelter that he was at. Well, I don't object to the non-monetary conditions, but in terms of cash bail, I don't think he has a whole lot of money to post. I'm wondering if the court would consider undoing the forfeiture and imposing just a slightly higher bail under these circumstances, maybe $100 more for a total of $400.
Oh, I appreciate the suggestion. I guess I tend to side with the state that it's his responsibility to know when his court dates are. It's his responsibility to make those court dates. He had relatively modest bail set on a pretty serious charge here. This is a substantial battery charge, so it's not on the lower end. Actually, I think the complaint alleges 2 separate batteries on 2 different days, one of which is substantial. And he missed 2 court dates in a row in 2 separate cases. I don't think there's a great basis for me to undo the forfeiture, and I really don't see the state's new request as being unreasonable. Pretty good argument could have been made for a $750 cash bail on this case at the outset. I'll set $750 cash bail. I'll continue the previously imposed conditions. Given this, I wonder if we should put it on for a prelim right away.
Please, and that you said then the forfeiture will stand, correct?
Sure, for now, though, that's
Yeah.
always an issue that can be readdressed in front of the
Sure.
assigned judge or something.
Yes, if
Yeah.
we could have a timely prelim.
Yep,
date
we'll
from
get
now,
that scheduled right away.
That'd be great.
Good luck to you, Mr. Abernathy.
Next up is Steve Emmons. Steve Emmons. No, but not the yellow, I saw this here, so.
We'll call the case of the state, which is Steve Emmons. It's case 25 CM 2728. Appearances, please.
ADA Sam Smith for the state.
Mr. Emmons appears in person and by Dorothea Watson. We have received a copy of the criminal complaint. We waive its reading. Reserving all jurisdictional objections, we would stand mute as to the misdemeanors and request a prelim as to the felonies.
I got some good news for you. He's only charged with misdemeanors,
Oh.
so you
Okay,
don't have to worry about the prelim.
and then the case number is changing or,
Oh, do you have oh, I see what's happening. Okay. Yeah, the pre-printed part of the
Mm.
criminal complaint has
Oh.
a CF.
Gotcha.
It was properly assigned a misdemeanor case number by the clerk. So
Okay.
the correct case number is 25 CM 2728.
thank you.
Sure.
Um,
Sorry to break in there, but that was good news, I think.
Yeah, I think it's, in terms of the address, it is accurate on the criminal complaint. And, Mr. Emmons is apparently not eligible for a public defender.
All right, so usually that means they're saying you make too much money or have too many assets. The deputy here is giving you a sheet that describes how to reapply at the public defender. You're always welcome to do that if you think your income's changed or the numbers were wrong or something. You're also free to hire a lawyer on your own or to represent yourself. If the public defender's office still says no, and you don't really think you have the dough to hire a lawyer on your own, there's a process where you can apply through the clerk of court's office. Sometimes they can get you a lawyer with like a payment plan. So you have an experienced criminal defense attorney here with you today, so you're covered that. So what's the state's position on bail?
The state is recommending a signature bond, along with the conditions that the defendant have no contact with Christopher J. Christopher's common spelling, that he not possess any dangerous weapons, and that he not consume or possess alcohol.
I do have some concerns. I believe this is a case where these people are neighbors and I'm concerned that they reside, I believe, in the same building. So in terms of no contact, I understand it needs to be restricted somewhat, but I would like to somehow acknowledge the fact, no intentional contact. I think there could be accidental, and I am concerned about that.
Sure, I don't know if the state has the additional response or a response.
I would just note, given what's alleged in the complaint and the victim reporting that the defendant pulled a gun on him, among other things, I think the condition is warranted.
I do too, but I think the concern is also a warranted one. I'm gonna order a signature bond with the no contact condition, as well as a requirement that he not be armed with dangerous weapons or consume alcohol. I think it's understood, and I'll say that here for the court record, that a violation of the court order is a violation if it's intentional. If there's sort of incidental contact in the hallway and no words are said, no gestures are made, there's no effort to provoke that contact or interact with the person, I don't see that as a violation of the bail conditions. Ultimately, if there's an allegation of a violation, the state will have to prove that there was intent to violate a condition of bond. That's one of the elements of a bail violation. But so I think the point's well made, but I don't know how to account for it other than I guess by noting that point for the record. We'll get a not guilty plea entered for Mr. Emmons. We're gonna get you another court date here in the next room. Good luck to you. Take care.
So,
You don't want to talk.
no, I won't talk about charge. I'm asking. I'm discussing. Why you have it? But I'm sure from my service tonight that they don't have to reclose my job. I have to be there at 6. Right.
Yeah, I kind of overheard that, but it usually is about an hour or a little more to get out. I think you should be good.
Yeah, they told my girlfriend, they gave me the 2 days, and I said, they're short for the service, they were posted, they had this job, so. I just
Well-
want to get that judge and keep it for down to citizens.
But let's get you into the next room so you can get through the process.
Right on it.
Take care.
Larry Miller. Larry Miller.
All right, we'll call the case of the state versus Larry Miller. It's case 25 CF 2343. Appearances, please.
ADA Sam Smith for the state.
Larry Miller appears in person and by Dorothea Watson. We have received a copy of the criminal complaint. We'd waive its reading, reserving all jurisdictional objections. We would request a preliminary hearing. The address on the complaint is accurate, and Mr. Miller is eligible for a public defender.
Okay, thank you. The booking sheet says that he's being held on a contempt warrant of some sort for Rock County. I don't know any more about that. Perhaps it's a support related thing or something. It also indicates that he's being held on a body only bench warrant in an Adams County misdemeanor battery case. So there is that also out there, but what's the state's position regarding bail on this charge?
The state is requesting $10,000 cash bail, along with the conditions that the defendant have no contact with TLH, no contact with TLH's family, and no unsupervised contact with minor children. Reason for the $10,000 request here, this charge carries a 25-year mandatory minimum on count 1 if he's convicted. Given the significant amount of exposure, I think a large amount of cash is necessary to ensure future court appearance. Thank you.
Well, thank you. And Attorney Watts?
Well, this is a 2021 allegation, wasn't charged, I think, until now, and because the state didn't know about it, but there was nothing in the complaint to indicate that Mr. Miller was attempting to contact anyone associated with these allegations. It's my understanding that he has lived in Wisconsin his entire life. He has adult children in the area. He is currently unemployed, usually works for cash. I'd ask that the court, if the court's going to consider cash, that you consider bail monitoring under these circumstances. This is a significantly older case, and we have no reason to think that he's not going to abide by any condition of bond that the court orders.
All right. And I know that I signed the warrant because it was presented to me by the state when the case was charged, but I don't specifically remember the facts on the complaint. So I do want to take a Just a second to look that over again.
Not for my, it must be the same thing.
All right, I did refamiliarize myself with the complaint and the allegations contained there.
Can I offer just a little bit?
Yeah, I was actually going to invite either of you to add
Oh,
anything.
thank you very much. I do appreciate that. Mr. Miller informs me that, in fact, he is employed and has been so for the last 2 months. He works for a company called Better Environmental Solutions. I did look it up online and there is in fact such an entity. He says he's worked there for the last 2 months.
All right, well, Mr. Miller is charged with an offense that carries a minimum of 25 years in prison in the event of a conviction. Of course, I don't know at this point whether there'll be a conviction, whether the case can be proven beyond a reasonable doubt. That necessarily has to get figured out beyond today, but I can't help but be concerned about the risk of non-appearance, given that that risk is not made better, or my assessment of that risk is not made better by the 2 outstanding warrants. One, I don't put much weight on because I just don't know what it's about. The other is missing what appears to be a known court date in a pending Act 3 eligible case. That takes us to the fact that this is also an Act 3 eligible case. I have a public safety assessment report that puts him at the very top of the risk for new criminal activity while on bond. It has the risk of new violent criminal activity flag present, and he's a 5 out of 6 on the risk of failure to appear. That document also says that he has 3 or more prior violent convictions. I bring that up because that's an Act 3 factor that I'm supposed to consider as well. I see the state's request as quite measured. I think a pretty strong argument could be made for a substantially higher bail than that, given those risks. At some point, a non-negligible risk of 25 year mandatory minimum in prison creates some pretty significant flight incentives. I'm going to set cash bail at $10,000. I will order that he not have contact with, I didn't quite catch the initials, was ELH?
T is in Tom, L is in Larry, H is in Harry.
Okay. Maybe I'm missing something. Isn't that different than? Oh, I see. The initials in the complaint maybe refers to either a parent or some other individual related to the alleged
I
victim.
think the child is just called child victim.
I think so too, yeah. I do find these complaints a little confusing when that's the case, but I do understand the reasons in this case. I'll order a no contact with that person, any member of that person's immediate family, and no unsupervised contact with minors. Let's put it on for a prelim right away, I assume.
Please.
Yeah, we'll get that scheduled. Mr. Miller, good luck to you with all this.
All right.
So the cash is how much?
10,000.
Next up is KAINE Rufus. Holly, I did listen to the live stream and it sounds normal. Thank you.
All right, we'll call the case of the state versus KAINE Rufus, case 25 CM 2540. Appearances, please.
ADA Sam Smith for the state.
KAINE R.T RUFUS appears in person and by Dorothea Watson. We have received the copy of the criminal complaint and waive its reading, reserving all jurisdictional objections. We would enter plea of not guilty to the charge.
Thank you. Oh, sorry, go
The
ahead.
address is correct on the complaint. It's not been determined if he's eligible for a public defender.
Yeah, so the booking sheet says that there is a probation hold. That might dictate a particular branch assignment, so I just want to check that out quick. Looks like that supervision is out of Washington County, so no specific reason to assign it to any particular Dane County judge. We'll just let the computer make that selection. What's the state's position regarding bail?
State's requesting $500 cash, along with the conditions that the defendant have no contact with ASHA H. That's ASHA. And a ban from all pawn stores and resale businesses. Reason for the cash request in this case, looks like I'm seeing failures to appear. One in particular for a jury trial in Dodge County 24 CM 162. That was on July 21st of this year. Other failures to appear include on June 9th of this year, June 17th of 2024, January 19th of 22, and May 10th of 21. For all those reasons, the state feels $500 is reasonable.
And CCAP does say that he does have an open felony case in Columbia County. I'm not sure about the timing of the charges, though. I think this may have be alleged to have occurred before that. Yeah, what's alleged in this complaint is something from July, and I don't think the case in Columbia started till September, still pending, but it's both those things are relevant. Attorney Watson, what's your position on this?
Well, the conduct alleged is from July of 2023, the theft of some AirPods. Given the nature of those charges, as well as the fact that if released, Mr. Rufus would be on community supervision, it appears. Of course, he could get revoked. Then it would be some time before he'd be out of custody. I'd ask the court give him a signature bond under all those circumstances.
Any response from the state?
No, thank you.
I think it's a pretty close call. I think there's certainly nothing unreasonable about the state's recommendation. I also do take into account that this is a property crime. There is that supervision tie, and I suppose that cuts a couple of different ways. I'm not hearing that he picked up charges for like running from the police or that he was an absconder or anything like that. And that I think is to his credit. I'll give him a shot with a signature bond here. I'll adopt the non-monetary conditions proposed by the state, and we'll get it scheduled for another court date. Good luck to you, Mr. Rufus. Take care.
Next up is XAVIER Over, appearing by Zoom.
Okay, let's call the case of the state versus XAVIER Over. It's case 25 CM 2733. Appearances, please.
ADA Sam Smith for the state.
Mr. Over appears by video. Dorothea Watson appears in person. I can inquire why we are using this procedure with Mr. Over.
I don't know.
Okay. It's random. Some people appear from the jail, some people.
Well, I mean, I think that the sheriff has protocols and procedures for when they think it's appropriate to bring somebody to and from court. And I don't know what the specifics are in Mr. Over's case.
So
I generally don't inquire because in the past, when there's been an inquiry about that, it's often led to the disclosure of fairly sensitive material that then winds up going over the live stream. Sometimes it's health related or behavioral or.
okay, it's a decision made by the sheriff is all I needed to know. That's fine.
That is accurate. yeah.
Okay, thank you very much.
Yep.
We have received a copy of the criminal complaint. We'd waive its reading, reserving all jurisdictional objections. We would enter pleas of not guilty to the charges.
All right, and Mr. Over does have an open misdemeanor case assigned to Judge Schlipper, so we should get this case sent to the same judge. Perhaps the state has a position regarding bail.
The state is requesting $300 cash bail, along with a ban from State Street. Reason for the cash, I'll start by noting there was recent cash bail set at $2,000 in 24 CF 379 and $200 in 25 CM 1580. In his most recent case, that I believe the court mentioned in branch 3, there was $300 cash bail ordered. That was recently amended to a signature bond. And then 5 days later, he's violating court orders by being on State Street. I think for those reasons that $300 is appropriate.
Attorney Watson.
Well, I would guess that $300 is going to keep him in the jail at least for some period of time, and I guess that takes care of business for a while. But it appears from this history that I've heard, as well as this criminal complaint, that Mr. Over probably is in need of some services. Would the court consider a signature bond and a referral to the bail monitoring program, who could perhaps help him find some assistance in the community?
And I should probably fill in some pieces here for everyone, and then happy to hear any responses or additional argument. That $300 was set on October 30th. And I have some recollection of that because it was only a couple of weeks ago. I believe at that time he had been picked up on charges occurring within either hours or maybe it was a day or two of when he had been released after serving a fairly lengthy sentencing after revocation on very similar prior charges. Now, the $300 is not holding him in custody because there was a stipulation last week to modify that to a signature bond, and that occurred on November 7th, which I guess would explain how the timing can work for the November 12th event described in this complaint. So I'm sort of throwing that out there, but either party has anything to add on, and I'm happy to listen to it or make
No.
hear any additional arguments.
Nothing more to add.
No, nothing.
And I neglected to write down the state's requested number.
That was $300.
Yeah, I thought a $300 cash bail was appropriate 2 weeks ago.
$69. I got $69. That's all I have to my name.
Okay, well, I'm sorry to hear that that's your situation, but
No,
I
I'm
can't.
going through a lot right now.
Yep, I hear what you're saying, but this is just not a signature bond case at this point. I think the state's request is pretty reasonable. I'll set cash bail at $300. I'll adopt the condition that he not be in the state and Langdon ban area as depicted on the map. He's gonna get a copy of that. I don't know how many times it's reasonable for us to have Mr. Over come in and get cash bail, have there be a change to a signature bond, and then have him just get rearrested basically right away. I don't have control over what happens beyond here, of course, but at this point, the state's request is to me more than reasonable.
He was not interviewed by the public defender's office. Do you still have a list you can put him on to make sure that they don't miss him tomorrow or Monday?
Actually, we don't.
Oh, okay.
If there's a way to communicate that back to the PD's office, that would be great.
Okay.
Yeah, I know all these processes have changed and I don't really have an ordinary way to add somebody to a list like that. But Mr. Over, they are gonna work on talking to you about getting you a lawyer, and I think that's important. Good luck.
Next up is DAIZHUAN Bridges.
All right, let's call the case of the state versus DAIZHUAN Bridges. It's case 25 CF 2011. Appearances, please.
ADA Sam Smith for the state.
Mr. Bridges appears in person and by Dorothea Watson. I have received a copy of the criminal complaint. I waive its reading, reserving all jurisdictional objections. We would ask for prelim if there's any felonies, or it looks like maybe, oh, one of these, yes, is at least a felony, and not guilty as to any misdemeanors. The address is correct on the criminal complaint.
All right, that's all sounds good. And what's the state's position on bail?
The state's recommending a signature bond along with the conditions that the defendant have no contact with HB and no contact with CJS, and that he not consume or possess alcohol. I'll just note failures to appear at out of custody IAs on September 29th and October 30th. I think there was an issue getting Mr. Bridges' notice, thus the reason for the state's request for a signature bond.
Yeah, it does prompt a question. I want to make sure we have the address right. I have 1106 Pine Street in Sun Prairie.
That is his address. I've just talked to him about that, and he'll make sure that his name is on the mailbox so that he can get mail
Yeah.
now. I noticed that things were not, mail was being returned.
Yeah,
So he will look into that.
that and it looks like the sheriff's office actually made 3 efforts to serve a summons for this case there too. Pay attention to that stuff because I think had that summons been served and you'd have made the court date, you wouldn't have been in custody on this. I do have to ask, did you turn yourself in too?
Yes.
Yeah, okay. I appreciate that. And all of this as a signature bond is probably the right answer here. I'll do that. We'll get a not guilty plea entered on the misdemeanor charges as suggested by counsel. And what about the time limits for preliminary hearing on the felony?
We'd waive them at this time.
Sounds great. Yeah, it's kind of a shame we had to go through this and have you in custody, but we'll get you another court date and hopefully things will go better from here. Good luck to you, Mr. Bridges, and good job coming in and dealing with it. Take care.
Next up is Travis Holt.
We'll call the case of the state versus Travis. Is it Holt? Holte? Holte, very good. Case 25 CF 2604. Appearances, please.
ADA Sam Smith for the state.
Mr. Holte appears in person and by Dorothea Watson. I have received a copy of the criminal complaint. I'd waive its reading, reserving all jurisdictional objections. We would request a preliminary hearing. Mr. Holte is eligible for a public defender. And the address is accurate. Apparently his address is 142 Blue Spruce Lane, Marshall, Wisconsin. Same zip.
Sounds great. And does the state have a position on bail?
State's requesting cash bail in the amount of $750,000, along with pretrial services and GPS monitoring if he posts. As far as other conditions, the state's requesting no contact with Nick R. No contact with the co-defendant Nicholas Thompson. No possession of any dangerous weapons. And no possession or consumption of alcohol. I'll note we are in Act 3 territory. What's being alleged, a witness saw defendant with a knife, heard him say, quote, "I will kill you, I will stab you." He also bragged about his backup to the witness. The victim had stab wounds in his back and had to be taken to the hospital where he's still located. And I believe there, as far as criminal history, an aggravated battery and second-degree reckless.
I wonder if there's a possibility you're reading the notes that relate to Mr. Thompson?
No.
Okay.
And I am going to correct myself as far as the aggravated battery and second-degree reckless. I believe that was dismissed back in 2018.
Okay, but that relates to Mr. Holding.
Yes.
Okay. I partially asked that question because if I'm reading the complaint correctly, I thought it alleged that Mr. Thompson was the person with the knife, but maybe I'm wrong about that.
I didn't say. Well, there is information, or at least that I have in front of me here, that's stating witness saw this defendant, Mr. Holte, with a knife.
Oh, and there is a spot on page 7 where it talks about him potentially holding a box of cutters. Yeah, I see what you're saying.
For all those reasons, the state feels significant cash bail is appropriate in the amount specifically of $750,000.
All right, any additional information before I hear from Attorney Watson?
No.
Okay, Attorney Watson.
Well, it's my understanding, first of all, in terms of his ties to the community, that Mr. Holte has lived in Dane County his entire life. He lives with his parents. He last worked in 2024 at Home Depot. He's currently unemployed. It does appear from reviewing the criminal complaint that the co-defendant Nicholas Thompson was the main aggressor here. Mr. Holte's parents contacted the public defender's office. They'd be willing to co-sign a bond with him. He does reside with his father. They might have some money to post, but $750,000 is way beyond what they could afford. Perhaps the court would consider something like $20,000 or $30,000. here. Given the nature of the offense, of course, cash bond is necessary, but given his part in it, I'd ask that you consider a lesser amount. We, of course, don't object to bail monitoring be involved.
Anything else from the state?
No, thank you.
Okay, I should take a moment or two to look at this complaint a little bit closer, and I can give you an answer here shortly, hopefully. All right, I have had a chance to review a little bit closer the criminal complaint.
Could I
Oh,
just
yeah.
add one thing, just the pre-sentence or public safety assessment does recommend cash bond, but it does appear he is very low risk for new criminal activity or for failure to appear.
Yeah, I mean, I think that's accurate. Everything except the charge itself and the concerns related to that tend to support Mr. Holte in terms of risk factors. He, according to it, has no prior criminal convictions, no history of missing court. Those are certainly relevant factors, and they're important ones in Act 3 bail analysis. So let's talk about that a little bit. So I'm supposed to consider the totality of the circumstances, including history of violent crimes. I'm supposed to consider appearance risk. I'm supposed to consider the general idea of community safety, the risk of witness intimidation, and I'm also supposed to consider possible affirmative defenses. I'm presented with no information suggesting he has a history of convictions for a violent crime. All indications are that that's a factor that would favor him. I'm not so sure that I think it's plain that he would flee or not appear in court in response to these allegations. They're serious. By any measure, they're serious. And they carry the possibility of up to 60 years in prison in the event of a conviction. There's a lot of space between now and a conviction and a sentencing on that. And Mr. Holte is certainly in a lot better position than many other people who are charged or potentially convicted at some point of an attempted first-degree intentional charge, in that he does not have that prior record. The facts in the complaint also suggest, though of course I wasn't present for any of it, but suggest that Mr. Holte was likely not the actual stabber. I think it's alleged that perhaps he was present with a box cutter and made some statements, and if what's alleged in the complaint is true, would provide a basis for party liability, but not necessarily that he's said to have committed the more violent of the acts that are described. I think there is a community safety risk. I mean, there's not only the fact that he's alleged to have been involved in an attempted first degree charge. There is the accompaniment of weapons. The whole setting, even from a defense perspective, seems to be kind of a drug deal that went bad, and that's none of that is great from a safety perspective. It similarly causes some concerns about witness intimidation. I am required to consider the possibility of affirmative defenses. In many cases, there aren't very many obvious affirmative defenses. This case is a little different that way. There is, I think, a real possibility of at least the assertion of an affirmative defense in this case, given how this is alleged to have gone down. Whether that's successful or not, I don't know ultimately. Just the same as I don't know whether an effort to prove the actual underlying charge is successful. That's what has to get sorted out later on at trial. But I do take into account the fact that I think there is at least a possibility of an affirmative defense in this sort of situation. As an aside, I don't, when I'm making these decisions, I don't discount the possibility of non-affirmative defenses either, including the burden of proof, because that's relevant to risk. But it's, I think this is a case where it has to be a substantial cash bail. I don't know that there's a good viable alternative to me in an Act 3 analysis here. My number is probably significantly closer to the defense number for Mr. Holte than the state's. Whether that difference is going to be helpful to him, I guess, remains to be seen. But what I would do in this case is set a cash bail at $100,000. I'll adopt the conditions that he have no contact with Nick R., that he have no contact with co-defendant Nicholas Thompson, that he not be armed with dangerous weapons, and that he not consume any alcohol. I don't think at this point I'm going to refer him to pretrial services for GPS monitoring, because I don't know that anyone's identified a location to monitor.
The reason for that request was to make sure we know where he is if he does post, but I recognize I did not ask for a specific location ban.
Yeah, I guess I can see situations where having tracking of the whereabouts of somebody makes a lot of sense, but I would tend to tie that to a situation where either the person is banned from a particular spot or is ordered to remain in a particular spot. I don't know that. If I'm doing that, it's because I'm concerned about flight, and I don't think that's the primary factor here. So I think I'll just not do that.
Well, Your Honor, I do note on page 6 of the complaint that there's an indication that Mr. Holte's blood alcohol was quite high when he came into the jail. Would the court consider a lesser amount of cash bond with a condition that he remain in his father's home certain hours of the day and comply with alcohol monitoring?
Well, I'm certainly happy to require him to go through alcohol monitoring and restrict him to his father's home, but I don't think I'm going to do it in exchange for a lesser amount of bail at this point.
Okay.
So why don't I just decline both requests in that regard? I'll not do the pretrial services referral. We'll put this on for a prelim right away. I think that's probably the request.
Please.
Yeah, and bail can certainly get reviewed at the preliminary hearing or after. Maybe a plan of the sort that's been described is a viable plan, but I don't know that it is today. Good luck to you, Mr. Holte. Take care.
Next up is DEMONE HAYNES, appearing by Zoom. Yep.
All right, let's call the case of the state versus DEMONE HAYNES. It's case 25 CM 2729. Appearances, please.
ADA Sam Smith for the state.
Mr. Haynes appears by video. Dorothea Watson appears on his behalf in court. I have received a copy of the criminal complaint. I'd waive its reading, reserving all jurisdictional objections. We would enter a plea of not guilty to the charge.
All right, thank you.
DEMONE HAYNES here, standing at y'all computer screen.
I'm sorry, Mr. I didn't quite catch that. Can you say it again?
DEMONE HAYNES, brother. God love you.
Okay, well, I'm glad we have this.
I'm just happy this morning. Good morning, sir. Good morning, Your Honor.
Okay, Yep, good afternoon. Good to see you here. So,
What's
Mr.
up,
Haynes,
brother?
city on a probation hold.
Yes, sir.
That means yep, that means we need to assign this case to a particular judge, though I don't know who that is. Maybe the clerk does.
Looks like that's Judge Kurtz.
Okay, real good. State of a position regarding bail?
The state is recommending cash bail in the amount of $750, along with the conditions, or condition rather, that the defendant have no contact with Victoria L. Reason for the cash request, it looks like the defendant's on probation for a pretty serious offense. I believe it's a first-degree recklessly endangering safety, with 3 years of prison hanging over his head, and certainly some concerning conduct while in custody here, at least what's being alleged. There's no prior failures to appear that I'm seeing, but there is a number of serious previous convictions. For those reasons, the state feels $750 is appropriate.
Attorney Watson.
I ask that the court consider a signature bond or certainly less cash than the state is requesting. Mr. Haynes would be on supervision if released or would not be out for a while if he got revoked and had to do some time. So it's academic maybe in a lot of ways right now, given the nature of this offense. I don't think that he is violent toward anyone, obviously inappropriate, but I'd ask that you consider a signature bond. It's not been determined if he's eligible for a public defender either.
I just thought I'd butt in really quick, by the silence. Just wanted to see when am I able to talk?
Yep, well, you probably don't want to because we record the proceedings and you have a lawyer who's made, I think, a pretty strong argument on your behalf.
I do want to talk. I do.
All right, well, it's up to you, but please keep in mind that anything you say can be used against you later on.
Mr. Haynes, I would suggest that you not make any statements at this
That's
time.
all right, ma'am. I don't even know you. Hello, my name is DeMond Haynes. I'm born June 18, 1996.
You know what that means?
One
That
thing
means Ms. Watson's been a lawyer longer than you've been alive, and she's giving you legal advice that
I'm
you
not
shouldn't
trying
really
to step
talk in
on her
court about
toes.
this.
I'm definitely not trying to step on her toes. I just want to speak for myself because I can go to jail. I can send myself to jail. You understand me?
Well, you're there now, but if you want to say something, I'm certainly not going to stop you. I'm happy to hear it. I
Yeah,
just
man, listen.
don't know if it's a good idea.
I struggle with laziness. I struggle with addiction to porn, to cigarettes, to murder, which I've never committed. Man, I love Jesus. I hate myself because I'm disrespectful, I'm rude, I need help. I'm an alcoholic. I've been drinking since 3 years old. That's the truth. You can check that. My first beer was handed to me by my father. I don't care about nobody else defending myself but me and my lawyer, Jesus. I'm not a Christian. I'm not a Bible thumper. I'm just keeping it real. I need help today. I need help. I raped a child before. I confessed to it. If y'all want to know the name, y'all can have me in y'all court, or y'all can talk to me right here. Any questions?
I don't have any right now.
DeMond Haynes, 428843, and my booking number, I'm not aware of it. DeMone Haynes.
Yep, that's okay.
I love Jesus, and he loved everybody in that courtroom.
Actually, you did a good job of citing, I think, your inmate number. That was good. Anything else that either of the lawyers wants to add?
No.
Well, I'm tempted, quite frankly, to raise
I don't
competency
need a bail.
based on his
I've
statements
been
here
sentenced
today.
to 3
I don't know
years.
that anything he has to say is really
Oh,
helpful.
extended
I don't
supervision.
think he understands what's helpful. I'm wondering if the court would order a competency
I had
evaluation.
a year and 4 months left of probation. Sorry, lawyer, go ahead.
Yep, Mr. Haynes, yep, I'm gonna have to look at a couple of things here and I'll tell you what we'll do here next in a second.
And only as many years as I've been a lawyer.
Oh, it's the same number. Sorry, I didn't mean to
No.
to date you incorrectly. So, this is one of those situations where I really could probably make either decision on the bail and they're both pretty justifiable. I'm not unconcerned with some of the things I've heard here or what's alleged in the complaint. There is an Act 3 history, though this charge itself is not an Act 3 eligible offense. I'm told that he doesn't have a history of missing court. He's on supervision, and as a practical matter, it means probably either he's going to be in custody, or if released, there'll be some level of supervision. I'm going to make that call in favor of a signature bond. That's not an expression of approval about what's alleged in the complaint or anything like that, but I don't have strong concern about his likelihood of appearance in court or not appearing in court. I think it's a fair point made about whether we should evaluate competency to proceed. I'm concerned about the behaviors described in the complaint. Mr. Haynes has made some statements here on the record that are very reasonable and relatable in a lot of ways. Others are a little bit more concerning, including sort of the judgment about whether it made sense to make comments in open court about it being addicted to murder, for example. I don't think that that's true, that he is, but it's the statement itself that causes me concern, and there's that. So I'm authorizing a signature bond on the charge itself. I will make a finding that there's reason to doubt competence. Without getting into great detail, I think a fairly quick perusal of CCAP shows some other reasons why that's probably an appropriate thing to review. We'll have that be on an outpatient basis. As a practical matter, if he's in the jail, it would be done there, but it's not my intention to require an inpatient examination as long as he cooperates with the process. We'll get a not guilty plea entered on his behalf to the misdemeanor charges. I think that takes care of everything for today. Mr. Haynes, I want you to put yourself in a position where you can forgive yourself and go forward that way. But I also want you to put yourself in a position where you're not picking up new charges and not having further problems. Good luck to you.
Next up is Tobias Jones.
All right, let's call the case of the state versus Tobias Jones. It's case 25 CF 2544. Appearances, please.
ADA Sam Smith for the state.
Mr. Jones appears in person and by Dorothea Watson. I have received a copy of the criminal complaint. I'd waive its reading, reserving all jurisdictional objections. We'd request a prelim as to the felony and enter a not guilty plea on the misdemeanor. The address on the complaint is correct, and it has been determined that Mr. Jones is eligible for a public defender.
All right, thank you. The complaint makes reference to a pending case. We should figure out where the case ought to be assigned. 1 second. Yeah, so he does have an open felony case assigned to Judge Burrs, so we'll get this case into the same branch. What's the state's position regarding bail?
State's requesting cash bail in the amount of $1,000, along with the conditions that the defendant have no contact with Paul W. No contact with any immediate member of Paul W.'s family. Banned from the 200 block of Webster Street. That's in Beaver Dam. Reason for the cash request here, it looks like merely 10 days after receiving a felony bond with a condition to have no contact with Paul W. What's being alleged is the defendant video calls him, accuses him of being a snitch in reference to an underlying case, threatens the victim and members of his family, indicates that he obtained their addresses. Given what's being alleged here, the quick turnaround and violation of bond conditions, I think $1,000 is appropriate.
And Attorney Watson.
It's my understanding that Mr. Jones has lived in Dane County the last 7 years. His whole family lives here, his family, siblings, and extended family. He is currently unemployed. He really has no money to post. $1,000 would be well beyond his means. The allegations here allege a phone call. I realize it's a violation of bail, but there's no physical violence involved or alleged here, I'd ask that you consider a signature bond or certainly much less cash than $1,000. He would not be able to post that or come near it.
The PSA describes a failure to appear within the last 2 years, a single one. I haven't dug to see if I can locate that. Does the state have information about that? Otherwise, Ms. Anderson may also.
Yeah, let me take a brief look, just one moment.
And I think Ms. Anderson turned on her microphone, so maybe she can help with that.
Yes, Dane 23 CM 2570, May 31st, 2024, a non-appearance for a status conference and a bench warrant was issued.
Okay, I appreciate that information.
And I guess the record probably is reflected just by virtue of that pre-sentence report that that recommendation is for a signature bond with pretrial conditions.
Yeah, that is true. So the case that has been described, Ms. Anderson described, does have the non-appearance with a warrant issued in May of 2024. The defendant subsequently posted a $500 cash bail. But following that, the case was dismissed with most of, well, a portion of that bail going to restitution and the remainder returned. So it did not result in a conviction, I guess, is the point I'm making with respect to the disposition there. I mean, the miss is still relevant. The demonstrated ability, albeit maybe a year or so ago, is also relevant. I see the stronger issues, though, as the concern about signing a signature bond and then allegedly within about a week contacting someone, accusing them of being a snitch, and engaging in these sort of intimidating behaviors that are described in this complaint. To Mr. Jones's credit, I think that the warrant that got issued in this new charge was served when he showed up to court in the earlier case, and he's shaking his head yes. And I think that makes sense given the timing. So I do give him some props for that. That's a good thing. I'm also sort of assuming that when he showed up, he didn't necessarily know there was a newly issued warrant for him. I can't overlook the nature of this alleged contact, the recent failure to appear. It's concerning. I don't mean to tinker around the edges of something here, but I think probably some number less than 1,000 is still workable. I'll set it at $750. I'll do that with the conditions that he have no contact with Paul W., that he not be in the 200 block of Webster Street in the city of Beaver Dam. We should get not guilty pleas entered on his behalf to the misdemeanor charge. Does he want a prelim within the next 10 days on the felony?
Please, if we
Yeah,
could.
we'll get that scheduled, and then I guess I'm gonna make the suggestion that if we're doing that, that we reschedule the other pending case, 25 CF 2426, for a prelim at that same time, rather than having it wait till January for the possibility of or for a status conference at that point.
That'd be great.
And is that acceptable to the state too?
Yes.
Okay, we'll do that. I think I omitted to mention not having contact with any member of Paul W.'s immediate family. I will adopt that condition as well. He's forbidden from doing that. So 2426, we'll pull off the January status conference and then schedule a prelim on that too. There's one other just sort of minor point I do want to make. Mr. Jones did file a pro se request for substitution in the earlier felony case. And that's there. It hasn't been acted on because of the procedural status of that case still being pre-prelim. My point here, Mr. Jones, is if you want somebody other than Judge Burrs to be assigned to this newest case also, you'll have to separately make a request for that. It doesn't happen automatically. Good luck to you, Mr. Jones. Take care.
That word, yeah.
Wow.
Yeah, and that's way back right now.
Okay.
Who is one? Martin.
THOR.
Thank you.
We go. All right, when we call the case of the state versus Lewis Thornton, case 25 CM 2736. Appearances, please.
ADA Sam Smith for the state.
Lewis Thornton appears by video. Dorothea Watson appears on his behalf. I have received a copy of the criminal complaint. I will waive its reading, reserving all jurisdictional objections. We would enter not guilty pleas to the charges.
Thank you. I know there are other pending cases. I just want to check on the branch assignment. He does have reopened misdemeanor cases assigned to Judge Burrs, so we will add this one. Does the state have a position regarding bail?
State's requesting cash bail in the amount of $1,500, along with the condition that he not consume or possess controlled substances or drug paraphernalia without a valid prescription. Reason for the cash request here. Looks like this defendant has 6 open cases across southern Wisconsin. There's one in Sauk, one in Columbia, and now I believe 4 in Dane County. What's being alleged here, he's violating specific conditions of bond, continuing to increase his exposure. I believe he posted $1,000 in his most recent Dane County case on October 27th of 2025. I'll also note bench warrants on August 7th, 2023, and across, I believe, 3 different cases on January 22nd of 2025. For all those reasons, I think $1,500 is appropriate.
Have like a preference or an idea of where you want to like stay or live? I don't think you're gonna be able to go home.
So I know there's some background noise there, and I know that's not Mr. Thornton, it's just, I think, other business being conducted, but maybe we'll mute the microphone so that everything can be heard on this side. I'll try to speak up so that he'll be able to hear things well on his side. Attorney Watson?
The basis of the bail jumping in this case is the allegation that he committed a new offense. That new offense carries a maximum penalty of 30 days in jail. I realize there's a repeater allegation alleged here as well, which could increase the maximum penalty. But I'd ask the court consider the fact that this is certainly not a dangerous violent offense for which he's alleged to have committed. And the related bail jumps, I guess, are there, obviously, but they are there because of a very, very minor misdemeanor. I'd ask that the court consider bail in the amount of $200, given his history and the nature of these now current offenses.
Any response from the state?
No.
It would be unusual for me to set bail on a new charge at an amount less than what a person just posted. But I also think there's something to be said for the point made by Attorney Watson about the nature of the charge itself. It is a relatively minor charge in the criminal justice system sense. It's not completely minor because there's probably a context that relates to the other charges that are pending. I would assume that at some point that will be the claim, or that will be the and probably is the reality. I'm willing to set it at $500. I'll do that. I'm not going to order the drug ban simply because it's against the law anyway. So it's a violation of bond one way or the other. It is according to the complaint, it has been made a specific condition in at least two of the other pending cases, and I think it's pretty enforceable whether I order it or not. So I don't see a reason to triple or quadruple up on it. We'll get a not guilty plea entered. Mr. Thornton, I do hope things start to get better for you. Take care.
Who are we moving to next? In theory, it will be Charlie Marchese. Next up is Charlie Marchese.
Okay, we'll call the case of the state. Oh, I thought that's my fault.
Set settles down. Just a heads up, it looks like these last three that we have on our calendar are all in setting in the same areas. So let's be rolling from one to the next.
All right, let's call the case of the state versus Charlie Marchese, case 25 CF 2559. Appearances, please.
ADA Sam Smith for the state.
Mr. Marchese appears by video. Dorothea Watson appears on his behalf in court. We have received a copy of the criminal complaint. I waive its reading, reserving all jurisdictional objections. We request a prelim on the sub-bat and enter not guilty plea as to the misdemeanor. The address is correct on the complaint, although I'm not sure about the number 30 after 8th Avenue. I'm not sure if that's part of the address. The information that he gives the public defender's office does not include that.
It is listed on the booking. We have it listed as 2633 8th Avenue, apartment 30, but maybe we can get them unmuted and let's talk about that.
Yeah.
Yeah. Yep, Mr. Sir, what's the best way to pronounce your last name?
Marchese.
Marchese, very good. And is the right address the 2633 8th Avenue, apartment 30?
Like bump stuff down.
I actually called there a lot 30, but I'm not actually 100% sure on that. I know for a fact that 2633 8th Avenue is correct.
I can't want you bailed out.
I'll see you one day.
Okay, so it sounds like, and I'm sorry for the background noise there, but it sounds like 2633 8th Avenue is pretty solid and you're not real sure about the apartment number.
You all got it?
Yep, and he's shaking his head yes in response to that. Well, why don't we keep it, because there's probably no harm in having it on there. And if you find out it's a different apartment number later, let us know, we'll get it updated. Not a problem.
Mr. Marchese has been found eligible for a public defender.
Okay, thank you. State of a position regarding bail.
State's recommending a signature bond along with the condition that he have no contact with Heidi G. It's HEIDI. Last initial G as in Gary.
No objection.
The booking sheet says that he was arrested on this charge on the 12th at 5401 Quarry Park Road. Let me make sure I understand this. He's alleged to have committed a battery at that location on November 1st, really on the 31st of October. was contacted there by law enforcement. Charges were referred. The state sought a warrant that was then served at the very same location.
I took it that this could be a group home or something along those
Yeah, I think.
lines, or a
training
day
facility.
treatment facility, yeah.
Yeah.
But I'm not sure exactly what your question is. I'd rather he not answer questions about.
No, I wasn't gonna ask him about.
Okay, okay.
Yeah, maybe it's a rhetorical point more than anything else, but it just seems like an odd set of circumstances that law enforcement would have contact with somebody, not take them into custody, refer it for charges. There would then be the issuance of a warrant as though the person was essentially at large, when it appears that they're at the very same location where the interview took place. I'll leave that out there. I'll let it go for now. Somebody will have to sort that out at some point later on if it winds up being relevant to anything. It's just an odd procedural history. I suppose it's a zero-sum game ultimately in terms of whether he'd been taken into custody and had an IA a couple days later, or got the warrant served and had an IA a couple days later. It just seems like an odd way to handle it. In any event, I'll go along with the joint request for a signature bond. That's fine, particularly in light of that history. It's his right to have a preliminary hearing within 20 days. Attorney Watson, should we put it on or wait till later?
No, we'd waive time limits.
Okay, real good. Mr. Marchese, good luck to you. I hope things go well going forward.
There's nothing else holding him.
No, not to my
Okay,
knowledge.
Thank you.
Next up is Karen Vega, here by Zoom.
Great. Let's call the case of the state versus Aaron Faga, case 25 CM 1837. Appearances, please.
ADA Sam Smith for the state.
Aaron Faga appears by video. Dorothea Watson appears on his behalf in person. I have received a copy of the criminal complaint. I'd waive its reading, reserving all jurisdictional objections. We would enter a not guilty plea to the charge. The address is not accurate on the complaint. Mr. Faga provided the address of 1819 Sunset Drive, Cottage Grove, 53573. He is eligible for a public defender.
All right, I appreciate that address update. I do see that this is a warrant return after a missed pretrial in front of Judge Peacock in early September. It does appear that the notice of hearing got returned by the post office for that. Wonder if the state has a position on bail.
Given that information, initially with a failure to appear at a pretrial conference, I was prepared to ask for cash. I know a signature bond was set on August 12th. If there was issue with, well, I'm seeing he got a signature bond out of the an in custody IA on August 12th. So my understanding is that he would have notice for that September 5th date. However, if that's in dispute, or I don't have any more information about that, so I'll defer to the court if the court feels cash is appropriate.
To me, it appears that both things are true. It looks like he would have received notice in hand. It also looks like for some reason it was mailed and then returned too, but I think you're free to make whatever argument you want.
I'm not asking for any specific amount. I'll defer to the court if the court feels cash is appropriate, given the failure to appear and issues with whether or not there was notice given.
Attorney Watson, any input here?
Well, I agree that I think a signature bond is appropriate. It looks like he appeared by video back then. Whether or not he got noticed, I don't know. Maybe that's why it was mailed as well. And I think a signature bond is appropriate.
All right, and the clerk is clarifying that it appears that, and this is consistent with the record, it appears as though the time of the hearing changed, and that might be why a subsequent notice was mailed. The notice he was given in hand said 1:30 on September 5th. The pretrial conference notice that was mailed changed that to 8:30. I think it's pretty clear he probably didn't appear at either of those times, but I also look at this as a standalone disorderly conduct charge. The circumstances of the alleged disorderly conduct are such where, I don't think they're so serious that they themselves would suggest that this is like a big cash bail type situation. And I'm not presented with information suggesting a big history of missing court or anything. I think it's worth trying a signature bond again. We'll do that. I'll continue the previously imposed conditions. I know that Mr. Faga will get that in hand before he's able to be released. Will you get the next court date in hand?
He will not.
Okay, so that means, Mr. Fagas, you're gonna need to watch that mail at the address there in Cottage Grove. If you're concerned that you aren't getting mail or something, you'd always be free to go on CCAP or call the court. The other thing, sir, is that if you have a phone that gets text messages, there's a process where you can ask to get message reminders that way too. I sure hope it all works out. Good luck to you.
I'm guessing this will be Mr. Thompson. Next up is Nicholas Thompson. You're in by Zoom.
All right, I think we're ready to call the case of the state versus Nicholas Thompson. It's case 25 CF 2605. Appearances, please.
ADA Sam Smith for the state.
Mr. Thompson appears by video. Dorothea Watson appears in person on his behalf. I have received a copy of the criminal complaint. I'd waive its reading, reserving all jurisdictional objections. We would request a preliminary hearing.
All right, thank you. The case is being assigned to Judge Highland. That's because that's where the version of the case pertaining to Mr. Holte got assigned. What's the state's position regarding bail in this matter?
State's recommending cash bail in the amount of $750,000, along with the conditions that he have no contact with Nick R, no contact with the co-defendant Travis Holte, and that he not possess any dangerous weapons. I'd also ask that he be referred to pretrial services for GPS monitoring if he posts. I know we talked about that a couple hearings ago. I'm not asking for a specific address ban or restriction, but I am asking for pretrial services. Looks like the defendant has had cash bail ordered in recent cases, $1,500 cash in 24 CF 800. That case resolved in I believe a battery conviction. I'll note failures to appear, Columbia County 21 CM 558 on March 9th of 2022. That was quashed March 16th of 2022. Another bench warrant July 12th of 2022. October 4th of 2022. He has been revoked off probation in the past. Here also what's being alleged is that the defendant was refusing to cooperate with law enforcement and hid in his house for at least 2 hours. We are in Act 3 territory. There is a witness that said Mr. Thompson struck first and the victim has several stab wounds to the back area, had to be taken to the hospital. And I'll also note there was a number of excited utterances to law enforcement. Quote, "If you threaten me, I can stab your ass. Otherwise, if I had a gun, his ass would be dead. I would have shot him," end quote. For all these reasons, and I suppose we talked about this in a previous hearing, but it looks like Mr. Thompson did engage in this conduct first, or certainly had a knife on him. For all those reasons, the state feels $750,000 is appropriate.
Thank you. Attorney Watson.
It's my understanding that Mr. Thompson is from Dane County, his parents still live here, siblings, he's lived here his entire life. Despite having a criminal history, he is still in Dane County, he's not leaving anywhere. I understand that the court is going to impose some cash, given the nature of these offenses, but $750,000 is well beyond his means. He has no money to post. I'd ask that you consider a lesser amount of cash.
All right, I know that Mr. Thompson wasn't present when we did the initial appearance for Mr. Holte, and, but naturally I have to make some comparisons. In that case, I wound up setting a $100,000 cash bail. I do think Mr. Thompson's in a less favorable position from a bail perspective than Mr. Holte has. I should back up a step and say that, it's a case that's eligible for, well, it's not really just eligible, it's required that I treat it using an Act 3 analysis. I'm supposed to consider the totality of the circumstances, including prior convictions for violent crimes, appearance risk, the need to protect the community from serious harm, the prevention of witness intimidation, in consideration of any affirmative defenses. The PSA report says that he has 3 or more prior violent convictions. The state made reference to at least one of those in its presentation of its position. But that's concerning. I'm supposed to look at the risk of non-appearance. That's a pretty real risk, I think, given the fact that Mr. Thompson is facing up to 60 years of potential incarceration in the event of a conviction. And if the facts in the complaint are correct, and I always have to have an if in there because that's one version of the events and it's one that would have to be proven later. But if that version is correct, including the statements apparently made to law enforcement by Mr. Thompson, this is not exactly a whodunit type situation in terms of the interaction between Mr. Thompson and the person who is said to have been stabbed. It's the evidence of that appears to be quite strong. There's the need to protect the community from the risk of serious harm and the witness intimidation risks. Those are also strong factors to consider, given not only the history, but also given the statements and what's alleged in the complaint. I am concerned about the failure to appear history, the prior problems with supervision, the prior convictions for violent crimes, and of course, the nature of the offense itself. As I said when we had the initial appearance with Mr. Holte, I don't ignore the possibility of affirmative defenses here. I'm supposed to consider that specifically. I think there's some potential for that, given how this interaction is described to have occurred. The same excited utterances that were referred to also at least lead, I think, to at least an inference that that could be an issue, that there could be affirmative defenses at play here. So I do factor that into the analysis also. Again, I think, oh, I'm sorry, go ahead, Ms.
Well, I don't mean to interrupt. I just had one thing to add.
That's fine.
Oh, just that Mr. Thompson also wanted the court to be aware that he is unemployed, but his only means of income is Social Security disability income. And so he has very limited funds.
Okay, I appreciate that information. I think this is a substantial cash bail case. I don't see it as quite as substantial as what the state seeks, but it's got to be quite a bit, and it's got to be just comparing things. It's got to be quite a bit more than the bail that was set for Mr. Holte. I'm going to set the bail in this case at $300,000. I will order as conditions that he have no contact with Nick R., Travis Holte, and that he not go armed with dangerous weapons. We're going to get it put on for a timely preliminary hearing. There is the opportunity for bail to be reviewed at that hearing. So, these decisions aren't permanent. It's what it is right now. And I'm going to decline to make the pretrial services referral for similar reasons as when we had the Holte case. The purpose in doing that, I suppose, would be for GPS monitoring. There's not a specific location that I've been asked to ban him from. There's not a specific location that I've been asked to, in essence, confine him to. And I just don't know that we generally use GPS monitoring to engage in generalized surveillance of people, even those who are on bond. Maybe that's something that can put into the mix as part of some sort of a plan for how to deal with bail after today or some kind of other adjustments. But right now, I'm setting a pretty substantial cash bail, and I think that's probably sufficient. Mr. Thompson, I do hope things improve for you. We're gonna move the case forward so that you can get a picture of where things are going and be heard more fully on all this. Good luck to you. Take care.
That's everyone.